approaches. Please state your name.
This courtroom session opens with what seems like routine procedural business, but underneath the surface, there's already tension building around one of the most sensitive decisions a judge can make: bond. Bond hearings might sound technical, but they carry huge consequences. They determine whether someone accused of a crime waits for trial behind bars or out in the community, and judges have to balance several competing factors: public safety, the defendant's history, the seriousness of the alleged crime, and the likelihood that the defendant will follow court orders. In this case, the defense immediately signals two important things. They want more time to negotiate a plea, and they want the court to reconsider the defendant's bond conditions. That tells us the defense is already thinking strategically. When lawyers ask for time to continue plea negotiations, it usually means there's a possibility the case could resolve without going to trial. But the bond request is where the drama begins. Because bond isn't just about money, it's about trust. The judge has to decide whether this person can be trusted to follow rules, appear in court, and stay out of trouble while the case moves forward. And as we're about to see, this particular defendant's recent history is going to make that decision a lot more complicated. So keep watching closely. The arguments you're about to hear aren't just procedural. They're the beginning of a debate over accountability, rehabilitation, and risk.
All right. What are we doing?
Your Honor, we're asking to adjourn to continue a plea discussion, and I would ask to address bond.
Of course you would. Is this the only thing holding her?
Yes.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Yes to bond.
Your Honor, we're asking for a personal bond in this case. I understand she did have a violation, but she has a thorough plan to maintain sobriety, including through CMH, full substance abuse and mental health treatment. She has an appointment set up with them already, including also the vitriol shots, involvement with her church. She goes to AA. She's really worried about getting out to work. She supports herself financially. And I think that this plan can set her up on the right track. So we ask you to consider that.
What is the plan? That's the plan?
Yes, treatment, AA, church. I think all of those things would be a great support system for her. And she did just get out of inpatient treatment recently, so that is fresh in her mind. She wants a chance to show the court that she will comply.
She got out, and then 2 days later, she's violating her tether.
It was admittedly a relapse that she deeply regrets.
This is a moment where the defense is trying to walk a very delicate line. They've just acknowledged something critical: a relapse. In cases involving substance abuse, courts often have to weigh whether a relapse represents a failure of responsibility or part of the recovery process. Addiction treatment professionals will tell you relapse can be common during recovery, but in the courtroom, especially when someone is already under court supervision, relapse becomes more than a personal struggle. It becomes a legal problem. The defense strategy here is clear. They're framing this not as reckless behavior, but as a temporary setback in someone who is actively trying to rebuild their life. They're emphasizing treatment programs, church involvement, and Alcoholics Anonymous meetings, all signals to the judge that there's a support structure in place. But here's the issue judges struggle with in these situations: timing. If someone leaves treatment and then violates court conditions just 2 days later, that raises serious concerns about whether the treatment actually stabilized the situation. And judges tend to focus heavily on pattern, not just promises. So the real question forming in the courtroom right now is this: is this defendant someone trying to recover, or someone who simply isn't ready to follow court rules yet? What do you think? Should relapse be treated with understanding in court, or does it show the court can't trust the defendant yet?
Response from the people.
Your Honor, when we talked about this last week, I reminded the court that this was a hit and run with an alleged BAC of 0.28. I'm not saying that this Kaminsky is somebody that needs to be in jail indefinitely, but I do think that the blank seems a little bit more concrete in any release with this grandmother.
Your Honor, may I respond briefly?
Go ahead.
I just wanted to point out that the incident allegation in this case was before her inpatient treatment, so she sought out that treatment herself. We have no objection to a scram tether, but I think
Didn't
that
she have a program for follow-up care after her treatment?
I believe so. I think that part of
Is
this
she
plan.
following that?
Are you following your plan?
Yes, I am.
And I think this is fairly concrete. She has an appointment on September 22nd.
After she got out of treatment, she was supposed to, there's another part of what her treatment would be. Did she continue with that?
what was the plan after treatment?
The plan after treatment was to go into IOP, which I did call CMH, but unfortunately there was no opening until the 22nd, so I can have a 90-minute evaluation so I can get an IOP. I am still following up with Michael Francis, which is an outpatient psychiatrist in the meantime, until I can get in there on the 22nd.
So the answer to my question is no, she didn't follow up with that. And then secondly, then again, 2 days after that, outside of the facts of the particular case, she was drinking again. So, and I'm not really hearing a concrete plan that's consistent with the inpatient that she received. So for those reasons, the court is going to deny the request for a bond. In this case, bond will continue.
And there it is. The judge makes the call. Bond reduction denied. This moment might seem quick, but it reflects a lot of reasoning that judges apply behind the scenes. When Judge Simpson says he isn't hearing a concrete plan, he's pointing to something courts value heavily: specific, verifiable structure. Treatment plans sound good in theory, but judges want evidence that those plans are already being followed. Appointments scheduled weeks away don't necessarily reassure a court that someone is stable today. Another key factor here is the seriousness of the underlying case. Remember, the prosecution referenced a hit and run with an alleged BAC of 0.28. That's extremely high. For context, the legal driving limit in most states is 0.08. A 0.28 BAC indicates a very severe level of intoxication. So from the judge's perspective, the concern isn't just about recovery, it's about public safety. When courts deny bond modifications in cases like this, they're essentially saying the risk of releasing the defendant right now outweighs the benefits of giving them another chance outside custody. But here's something interesting. The judge didn't say the defendant should be held indefinitely. Instead, he said the plan wasn't convincing enough yet. That leaves the door open for future arguments, if the defense can show stronger proof of compliance.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rasmussen, who approaches the podium.
Your name, sir?
David Rasmussen.
All right, what are we doing?
Your Honor, discovery in this case is complete except for the 911 calls. I've spoken with the prosecution. Those are already been ordered. We're asking the court to set this for an exam, please.
Your Honor, it should be involved before the exam.
All right. I'll mark that if they're not in, you would not be entitled to an adjournment based upon not having those. But people have their witnesses available to 16.
We'll do our best, Your Honor.
Preliminary examination will be set September 16th, 2025, 9 a.m. That's before Judge Perry.
Thank you, Your Honor.
Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Rasmussen is a general contractor, self-employed. He's been in custody for some time now. We understand these charges are somewhat serious. However, reading through the discovery, I think that a personal recognizance bond with a no contact order would be appropriate in this matter.
Now we move into a completely different case, and the tone shifts dramatically. The defense attorney here is asking for something called a personal recognizance bond, often shortened to a PR bond. That's essentially the court releasing a defendant without requiring cash bail, based purely on their promise to return to court and follow conditions. Defense attorneys typically argue for PR bonds when they want to emphasize three things. The defendant has strong community ties. They're not a flight risk. They're not a danger to the public. And notice the strategy the lawyer is using here. He's painting a picture of his client as an ordinary working man, a general contractor, struggling financially, driving an old pickup truck, just trying to get back to work during his busiest season. This is a classic courtroom technique, humanizing the defendant. But here's where things often get complicated in bond hearings. Judges don't just evaluate a person's job or financial situation, they focus heavily on the nature of the allegations. And once the prosecution responds, the tone of this case is about to shift from sympathy to something much darker.
He's not to go to the address where the complainant is living, and he just wants to try and get back to work. This is his busiest time of the year with painting and getting people ready for the winter. And quite frankly, his 1987 pickup truck's in impound anyway. He's not a man of means, Your Honor. So $2,500 may as well be $250,000 to this man.
Respond.
Object to any modification of bond. In this case, the defendant was angry at the victim because he thought she was sleeping with someone else. He then pushed her on the bed and strangled her with 2 hands. He later punched her in the face, and she had bruising around her eye. He also took her phone so she couldn't call 911. And when officers asked her about the strangulation incident, she said it's happened previously 4 times in the last month, and he always uses both hands and tries to make her pass out. So I give great insurance for her safety. I would also ask for, if he is released at some point, I was not sure if the tether was ordered, a GPS tether for address, I would have to get that also be ordered, but it's just how I would reject any modification of bond.
It looks to me like it was ordered. Anything else, counsel?
Your Honor, I don't want to get into the merits of the case, but the same report also indicates that the victim was the first to be arrested till she changed her story and they decided to issue the warrant against my client. Additionally, she indicates she doesn't want to prosecute my client. So we can read the report or we can read the whole report, Your Honor. I don't believe he's a danger to the community at large. He has a very minimal record of one operating while impaired, I believe 7 years ago. I don't believe he's a danger to the community. He's a homeowner in Ann Arbor. He's lived here his whole life. He's 56 years old. He just had his birthday in jail over Labor Day. We're just trying to get him back out so he can work, because otherwise he's probably even going to lose his truck if he can't pay the impound fees on that. And again, we're talking about a 1987 pickup, Your Honor. We're not talking about a very wealthy man. He was willed the deed to the house from his mother, and he lives in his family home.
Well, at this time, based upon the information that's in front of me, I'm not going to change the bond. I wouldn't find that the magistrate setting a bond would be an abuse of discretion. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Once again, Judge Simpson declines to change the bond. And the reasoning here follows a familiar pattern. When judges say they won't find that the existing bond is an abuse of discretion, they're essentially saying the original decision to set the bond was reasonable and justified. That phrase is important in legal contexts because it sets a very high bar for changing bond conditions. The defense has to show that circumstances have significantly changed or that the original bond decision was clearly unfair. In this case, the prosecution's description of repeated violence made it extremely difficult for the defense to meet that standard, and this highlights one of the hardest realities of the justice system. Bond hearings aren't trials. The judge isn't deciding guilt or innocence yet. Instead, they're making a risk assessment. Is the defendant a potential danger? Could the alleged victim be harmed again? Would releasing the defendant undermine public safety? Those questions often outweigh arguments about employment or financial hardship. And for this defendant, the court clearly decided that the risks were simply too high.
Court calls the case People versus Annie Oglesby.
Good morning, Your Honor. Bells for the people.
Where is she? Oh. Here, I thought you had enough yesterday.
Never.
Your name, ma'am?
Annie Marie Oglesby.
Good morning, Your Honor. Tina Saxon for Miss Oglesby.
Okay, she's in. Got it. All right, thank you. All right. What are we doing?
Your Honor, there are now 2 cases. I just received the newest case yesterday. I don't have any discovery for that, but I did file my appearance and request for discovery yesterday. For the first case on this matter, I'm going to ask for an adjournment because there's an overlap between the 2 cases. It looks like it's coming out of 2 different jurisdictions, but for the same offense. So I'm asking for an adjournment so that we can track these together if the court is in agreement with that.
Yes, I will adjourn it. Currently, she's being, okay. Probable cause conference will be adjourned September 11, 2025, 9 a.m.
Your Honor, since this matter, I have to ask for another date. I will be out of state, returning that day. But
I can do the 18th. Will that work?
Yes.
September 18th, 2025, 9 a.m.
Your Honor, when
will continue.
I'm sorry, there was a bond violation that.
Yes, there was. Pardon?
Your Honor, as you remember on the first violation, Ms. Oglesby was in custody.
At this point in the hearing, the courtroom shifts again into another critical issue, bond violations. And in criminal court, violations carry serious weight because they signal to the judge that a defendant may not be complying with the conditions that allowed them to remain out of jail in the first place. Bond conditions often include things like drug testing, check-ins with probation officers, or attending treatment programs. These conditions aren't optional, they are court orders. When someone misses a test or fails to report, the court interprets that as a possible breach of trust. But here, the defense raises something that courts hear surprisingly often: financial barriers. According to the attorney, the defendant allegedly couldn't afford the testing fee, which prevented her from complying with the requirement. That introduces a complicated legal and ethical question the justice system has struggled with for years. Should someone lose their freedom because they cannot afford a required test? Courts generally say the responsibility is still on the defendant to communicate with the court or probation officer before missing a requirement. But situations like this reveal how financial constraints can quickly escalate into legal consequences. And as you're about to see, Judge Simpson is going to focus less on the explanation and more on the fact that the test was simply missed.
The second one, she simply did not have the money. She had lost her job while she was in custody in the other jail, and she couldn't pay for it. Therefore, they would not allow her to test. And now she's in custody again.
She didn't report for intake. So I don't know how that happened.
She stated that she called and left 2 messages with the community health and never received a phone call back.
Well, my understanding is she didn't report. We sent over another order. She, again, did not report for intake or testing.
Again, yeah, she lives in Jackson, which I stated
okay, that's like 35, 40 minutes away. And she didn't report twice.
She could not report the first time, Your Honor. She was in jail.
I was in custody in Eaton County.
Right.
So I understand your position, at least on the second time. She did not report for intake or test. I'm just providing the explanation for the failure to test. It's not free and they would not do it without it, but I understand your position on the intake.
It's considered a dirty job in Jackson if you don't have the money.
I don't know what that has to do with this. You didn't report to our community correction.
Ms. Oglesby, don't speak.
All right, I don't need a response. Motion for bond reduction is denied. Bond will continue. Thank you.
Another bond reduction request denied. What stands out here is how the judge responds to the explanation about money and missed testing. From the defense's perspective, the defendant wasn't trying to avoid testing. She simply didn't have the funds required to complete it. But from the judge's perspective, the court system works on a much simpler rule. Court orders must be followed. When someone misses required testing, the judge has to ask a fundamental question. If the defendant cannot comply with the conditions now, how can the court rely on them going forward? There's also something subtle happening in the judge's response. When he cuts off the explanation and says he doesn't need a response, it signals that he believes the facts are already clear enough to make a decision. Judges do this when they feel further argument won't change the outcome. In other words, in the judge's mind, the issue isn't whether the defendant had a difficult situation, it's whether the court can confidently enforce its conditions. And right now, the answer appears to be no.
Versus Randall Jolly.
Nickel for the people here.
Judge Mark Ellis representing Randall Jolly. Sir, please tell the judge your name.
Randall Jolly.
Your Honor, this is a PCC. We're requesting an adjournment of that, but as the court is reviewing, we have a bond violation.
Yes.
May I address the bond violation?
Yes, please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells them don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my
want, but go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids, because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine. Yes, he has a prescription for that. He today can pull out of his pocket a copy.
Now we enter one of the most complicated parts of modern drug testing in the criminal justice system: prescription medications and false assumptions. The defense is explaining that the substance detected in the defendant's system, buprenorphine, commonly known through medications like Suboxone, is actually prescribed. This medication is frequently used in opioid addiction treatment programs. It helps prevent withdrawal symptoms and blocks the effects of stronger opioids. So technically, the presence of this drug is not necessarily illegal if the defendant has a legitimate prescription. However, the judge's concern goes deeper than that. Courts don't just look at what substances are in someone's system. They look at patterns of testing compliance. Here's where things get tricky for the defendant. Even if one drug is legitimate, the court is still seeing missed tests, previous positive results, irregular testing patterns from a judge's perspective that creates uncertainty. And uncertainty is something courts dislike when it comes to supervision and public safety. So the question in the courtroom right now isn't simply, is this prescription valid? It's, can the court trust the testing results and the defendant's compliance moving forward? And the judge is about to push hard for clarity.
Of his pill bottle showing his prescription.
Oh, he told about grabbing it out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay.
Yes, Judge.
Can I say?
Shh. No.
But you're saying he didn't know that he had the test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last two tests. The only reason he missed the last two tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond.
What was the other drug, the amphetamine?
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test. Yes. Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then he has been clean. He missed the two tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's.
Your Honor, may I say something? I'm sorry to interrupt. I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home.
This moment is where the defendant personally addresses the court, and it's one of the most humanizing moments in the entire hearing. He's describing something many working people can relate to: a demanding job schedule, long commutes, and the fear of losing employment. In his case, he claims the testing facility closes before he gets off work, creating a logistical conflict between keeping his job and meeting the court's testing requirement. But here's the difficult reality of the legal system. Judges hear explanations like this every single day. People often say they missed appointments because of work schedules, transportation problems, or financial difficulties. While many of those explanations may be true, the court still has to maintain consistent enforcement of its orders. That's why Judge Simpson keeps returning to a central issue: communication. If a defendant knows there's a scheduling conflict with testing, the expectation is that they notify probation officers or the court before violations accumulate, and this is where things become a credibility test. The judge has to determine whether this is a genuine logistical problem or whether it's a pattern of avoiding supervision. What do you think? If someone's work schedule truly prevents testing, should the court adapt its requirements, or should the responsibility remain entirely on the defendant?
I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
No, Judge, I had no idea there was a problem, but I will say this. When I found out this morning there was a problem, I called testing facilities and I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean, I
don't mind paying the money. It's the facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how that works.
I want to fix this. I do. I really do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. Then when you know you haven't tested.
Sorry, Judge. I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in a system is Suboxone, but that's not everything that's showing up in a system from the initial test. And then I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
yes,
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming up.
I just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this offense date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall, which will show up in his system as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had that amphetamine in his system. Granted, it was right after he was released from custody, but without the ongoing testing, there's really no way to ensure the safety of himself or the public traveling back and forth so much on our roadways. If he's not clean, I have the same concerns that the court does, but can't add anything additional.
Anything else?
Judge, I wish there was an easy answer.
Your Honor. Yeah.
If the court allows, he will spend $150 in test at a private clinic.
Could have done that before.
Yes, absolutely.
That's my point. My point is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have I don't have any testing. Simple as that.
You don't.
So one I really did. My probation officer, well, she'll tell you. Fine, here, sorry.
Court test him today.
I can't get them in because of time.
Well, he said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you.
I have not taken none, I swear.
You know what? You need to be quiet about now.
This is one of the most dramatic moments in the entire hearing. Instead of continuing to debate hypotheticals, the judge decides to do something very direct. Test the defendant immediately. This move changes the entire dynamic of the courtroom. Up until this point, everyone has been arguing about past tests, missed appointments, and conflicting explanations. But an immediate drug test cuts through all of that. It provides real-time evidence. Judges sometimes do this when they feel the situation has become too tangled in arguments and speculation. By ordering a test right away, the court can quickly determine whether the defendant's claims about being clean are accurate. But the stakes here are incredibly high. If the test comes back clean, the defendant gains credibility and may keep his bond. If the test comes back positive for illegal substances, the judge has already warned that jail is a real possibility. You can actually feel the tension in the courtroom at this moment. Everyone, the attorneys, the defendant, and even the judge, knows that the next few minutes could determine whether this man walks out of court or goes straight into custody.
Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counsel, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. No answer yet. You need to go over there, see if you can test. You don't get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No.
Okay. Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still got to come back here.
Sure.
And if you don't test, you're going.
Thank you, Judge.
Bye. He calls the case the people versus Randall Jolly.
Reagan. Sure, maybe for the people within your honor.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument. You're going. Simple. And then the other portion of that is that I will allow defendant may test what county is that if you live in?
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County. at an approved facility by the community corrections.
Apologize, Your Honor, may I have the PCC date one more time?
Is the 18th.
Your Honor,
His test results, he must sign a release so that his test results are sent to community corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, is that good enough?
If as long as community corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to community corrections so that they can be reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at community corrections?
I do not.
And just like that, the tension breaks. The immediate test results show something important. Aside from marijuana, the defendant tested negative for all other substances. That dramatically changes the judge's risk assessment. Instead of seeing someone actively using dangerous drugs, the court now sees a defendant who may have struggled with compliance but isn't currently showing signs of serious substance abuse. However, notice that the judge still delivers a strong warning. He allows the bond to continue, but makes it crystal clear. Another missed test will not be tolerated. This is a common approach judges use, giving the defendant one final opportunity while setting strict expectations moving forward. The court also solves the logistical problem by allowing the defendant to test in Allegan County closer to where he lives. That shows something important about the justice system. While courts enforce rules strictly, they can also adapt conditions when a practical solution is presented. So in the end, the hearing closes with a balance between accountability and opportunity. The defendant keeps his bond, but the message from the bench is unmistakable. Follow the rules from this point forward, or the consequences will be immediate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.